Do you want to own a rental, or possibly you already own one and you want to know what the state guidelines are around selling, eviction, that type of thing? Well, that's what we're going to be discussing today. Krista Mashore here. I'm with Richard Hobin. He is attorney specializing in real estate.
Hi, Krista. How are you?
Thanks for being here. I've known Richard for a long time. Have a lot of respect for him. I've personally hired him myself to help me with a few things. So we want to talk to you today about what's happening right now with a new law that was passed regarding tenants and owning rentals. And this will be really helpful for people who are thinking about buying a rental, people that have rentals that might be thinking about selling. So what can you tell us?
Big changes since even before COVID. In 2019, there was a Tenant Protection Act that was passed. And it's AB 1482. And that set up a whole standard where the state is attempting to help stabilize the rental market. So basically what the state did, from my understanding and dealing with it, is it separated the owners of real estate into two different groups. And there's the professional, if you will, property owners and owners of rental properties, corporations, LLCs, folks that own a lot of properties, and 4 or more single-family units, multiple complexes, those sort of things. The AB 1482 says with regard to that group that they're going to impose upon them some rent restrictions, increases, and also limit their ability to do evictions unless there is just cause, for cause eviction. And that's kind of one area. The other side of the coin is those folks that own rentals less than 4 or less single-family units, or they have room rentals in their own home, that sort of thing. And under that group of renters, they've made exceptions or exemptions for them for the stronger rules that apply to the commercial renters of property. So you can still, with regard to the folks that own maybe 1 or 2 rentals,
or 3 or 4, right? So it's 4 or less. Okay,
yes.
Up to 4.
I don't think their lives are going to change much with regard to the eviction process itself. However, they've got to give a notice of exemption saying that they're not, that they're exempt from the provisions of 1482, and once they've given that notice, then they can move forward. Pretty much, failure to pay rent, that sort of thing. The issue of whether or not they have to have any kind of cause to do an eviction, generally some of the older rules are going to apply, and as long as people aren't discriminating or doing intentionally bad things, they're going to be able to get back the possession of their property in some reasonable period of time. They've got to jump through a few more hoops. But the folks that are really impacted, I think, by the law before COVID, again, are the people that are commercially offering properties for rent on a large scale.
So do me a favor, give me an example of when you said it's not going to help people that own investment properties between 4 or less, and they're the traditional types of things you do when you need to evict still remain in play. So what would that be?
Well, the thing now is, again, if a tenant has been in the property for less than a year, then you could use a 30-day notice. And if the person or the tenant or their group of family members have been in the property for over that year period of time, or collectively, there's a kind of another twist. If it's collectively by adding up the folks who have been there for a 24-month period, then you have to use a 60-day notice to terminate. Question of whether or not you can use a 60-day notice to terminate, again, it's kind of a standard provision. If they're exempt, there may not be a requirement that they occupy the property themselves, or that they want to repair or remodel the property to do substantial improvements. I think they're going to avoid those sort of requirements on an individual side of things, but on the commercial renters of properties, i.e. I have 10 homes,
okay,
and I want to evict a tenant under those circumstances, then I'm not going to be able to serve a 60-day notice I'm going to have to follow without cause. I'm going to have a legitimate reason to bring to terminate that particular tenant's right to be there.
So it no longer can be, hey, I want to move into the property, or it no longer can be, I need to do repairs here and there's problems, I need you to move out. You can't do that now.
Well, they can, but they have to state it for cause.
Okay.
Whereas if I'm an owner of a piece of property and I want to get back the possession and I have a few units, I can give a 60-day notice and generally get back physical possession.
Without telling them why.
That's right.
Okay.
But with regard to the commercial type renters of property, they're going to have to prove the cause. They're going to have to show a reason. Now, what would be probably the most difficult situations, I think, will arise in those multiple rental units, apartment complexes, that sort of thing, where you have a situation with some difficult tenants. Maybe you have a group of young tenants that are there, and maybe they're violating the rules. Maybe there's drug use. Maybe there's a bunch of other things, and or they're creating a nuisance on the property. And so you're going to have to establish those kinds of claims, i.e. there's got to be people arrested on the property, maybe for drug use, or maybe there's cultivation, or maybe there's violence on something. So it's going to have to be a pretty substantial reason to want to terminate their right to be in these properties.
All right. So, you say you have to have cause in order to evict.
Right. And it's called the Tenant Protection Act of 2019.
Mm-hmm. And by the way, Richard Hobin is an amazing person. He helps with evictions and everything else. He mostly only works for sellers, correct? You are there to protect sellers.
Well, we want to protect everybody's interests in general. I mean, I meet with I talk to a lot of tenants on the phone. I mean, you talk with a lot. You talk with a lot of different owners and tenants and all of the stuff. You got to be pretty careful because you can give general information, but you don't want to form an attorney-client relationship if it'll eliminate your ability to provide services maybe to an owner of a piece of property because you chatted with somebody briefly. Mm-hmm. So you got to be a little bit careful with that. But again, it's just fairness.
Yes, doing the right thing.
It's fairness on both sides. It's, what do I want from a tenant if I own a piece of property? I want them to pay the rent on time, and I want them to take care of the property. Mm-hmm. Pretty simple stuff.
And respect their neighbors.
You're good. Just be a good citizen in general.
Yes.
And if you do that, then I don't have any reason as an owner to want to have a tenant move. I mean, why do I want to go through the cost of having to do all the additional upgrades and repairs and whatever? And I want to provide a nice, safe, comfortable place for somebody to be. Now, if I have to sell it, or there's some set of circumstances that require me to get back physical possession, such as I have to move into it, then that's okay. And what I look for out there again is that, if a tenant calls me and someone is not being fair with them, I want to hear that, mm-hmm. because, and the same with the landlord. A landlord comes in, and the first thing I tell a landlord when they come in and they tell me, hey, the tenant hasn't paid rent. Well, the first thing I say to them is, I want you to understand your rights to real property, to the rental of real property. You own the land, and when you own the land, you have two rights. You have the right to ownership, and you have the right to possession. And if you live in your home, both of those rights are together. They're merged. But if I decide that I'm going to go into the rental market, then I'm still going to own it, but I'm separating possession, giving that to a third person. What does that mean? That's their home. So I have to respect that. I can't go into their home. I can't, without giving proper notice and all the rest of it. And if I want to get that property back, even if they're not paying rent, I have to go through a specialized procedure in California that even though the exempt owners of real property, I believe, are going to be able to continue to process unlawful detainers in kind of a standard way, it's much more complicated. They've taken the process now, and it's probably 4 times as complicated. There's 4 different papers, the notices, the summons, everything has changed. And in
evicting someone.
That's right.
In the eviction process.
It's going to be more expensive in terms of owners wanting to get back property. So if you're an owner of a piece of property and you're renting it out and you decide to sever ownership and possession, okay, I would recommend that you immediately take the rent that comes in, obviously, if you're having to pay mortgages and that sort of stuff, but you need a reserve account because, you know, I wouldn't feel comfortable in California not having a $10,000 reserve account in case something comes up.
Or a certain amount of months, right? Because the eviction process takes usually, what, 4 months-ish?
Yeah, again, it depends, you know. Right now with the notice to secure, again, if you're talking on the side of more of a commercial rent owner versus the individual owners with a limited number of properties, you know, you can still give a 3-day notice. With the other side, more commercial, it could require a 15-day notice. So again, those actual processing of evictions may take different amounts of time depending on what type of ownership you have.